Next, we welcome two leaders from CASE, the California Attorneys, Administrative Law Judges, and Hearing Officers in State Employment. Talene Ghazarian, and pardon me if I'm mispronouncing your name, is the president of CASE's Board of Directors. She's a special projects attorney with the California Department of Healthcare Services, representing the department in administrative litigation, provider appeals, and personnel matters. Her career spans more than a decade across the government, public health, oversight, and legal leadership, including service as Acting Chief Counsel for the Office of Youth and Community Restoration. Talene holds a JD in Health Law from Boston University and a Master of Public Health from University of North Carolina at Chapel Hill. Joining her is Peter Chau, a member of CASE Board of Directors, elected in 2025. Peter is an attorney and CASE local representative at the California Public Utilities Commission and graduate of Dartmouth College and UC Law San Francisco. Together with his fellow board members, Peter represents more than 5,700 attorneys, administrative law judges, and hearing officers. Peter draws inspiration from his personnel experience and his work with the state employees, especially in educating CASE members about the legal rights during the reasonable accommodation process. So, without further ado, please join me in welcoming Talene Ghazarian and Peter Chau. Floor is yours.
Thank you very much for the introduction. As you mentioned, I say Talene, like Celine, but answer to most things. As mentioned, Peter and I come from the CASE union, and we're both heartened to already hear, the value of unions being heralded even by the speaker and questioners before us. We're both newer to leadership for this union. We are about 7-8 months in, and trying to bring about a lot of change, trying really hard to get our members more activated, kind of act more like a real union than ever before. And it's been a lot of work. Our entire board is fully volunteer, so we're all working our day jobs full time on top of serving the board. But we're very honored to be invited and in such great company, and learning alongside you all. Peter's been doing a little bit more of the direct work with members on a lot of the reasonable accommodations, etc. So I'm going to pass the mic to him to kind of take over, and I'll jump in as needed.
Thank you, President Ghazarian. Good morning, everybody. I'm Peter Chau. For those in radio land or listening to the audio only version, I'm wearing a white collared shirt with a gray suit, and I'm on my background is light blue with the CASE logo on I think it's my left. It might be on the right, depending on how you're looking at it. I have short black hair. My pronouns are he and him, and I identify as Asian American or Chinese American, whichever you prefer. I'm also an attorney, as Talene has stated, and a part of my recent election on the CASE board was what I consider to be a decisive mandate from our members to be more inclusive, to have a big tent, to make sure that many of our members who have gone many years without hearing one peep from CASE, that they felt not only were they communicating with CASE, but also feeling like they were being heard. And that is a hard thing for us to do. Thanks to the leadership of President Ghazarian, we've set up a new environment and laying the seeds for this new environment of inclusivity. And that's included, for example, reasonable accommodations trainings for our members. Even though we are attorneys and administrative law judges and hearing officers, many of us actually didn't even know our own rights. So it was really important to me as an individual board member to put together a good training that not only educated our members about their rights, but also some best practices on and suggestions on how to obtain medical documentation, as well as how to navigate the state's interactive process. Before I go any deeper, I just want to make sure that I acknowledge all of the wonderful leadership and all of the hard work that our predecessors have put into this government entity, into this entity. I know that there have been many people, many generations, many hard workers who have put heart, blood, and soul into this committee and into the work of advancing disability rights. And I want to acknowledge that because for many of you, this is probably your first time seeing me in front of your screen discussing disability rights. And as a newcomer, even though I've been with the state for almost 9 years now, I realize I may be a newcomer to this scene. And I just want to make sure I acknowledge and thank everybody who came before me. And I look forward to working with everybody in collaboration to advance disability rights because we are stronger together. When you think about it, people with disabilities have a skill set that makes them an attractive candidate for state employment. Considering all the challenges that we've had to overcome, whether it's navigating a bureaucracy with an insurance company, whether it's communicating with a medical provider, whether it's internal issues that you have to deal with. The fact is that there's a lot of adversity that many members with disabilities have had to overcome, and that has developed an amazing skill set that would make you an attractive candidate to state service. And I feel like it, even though I'm here to represent the 5,700 members of my union, I just want to make sure I communicate to every state worker out there that I feel you, and I feel a lot of the anxiety and stress and many of the things that are frustrating about the recent return to office mandate. And know that, with any movement, right, any type of progress that's made, there's always going to be, unfortunately, some setbacks. And I view the RTO mandate as a setback because of the fact is that we've been turning away from telework rights. During the shutdowns, our workforce relied on telework, and we saw amazing policies that allowed employees to enjoy telework, even people with disabilities, and to be able to continue working from their homes, advancing their work. Now, whether you are protecting ratepayers, like at my department, or whether you're working to protect the public health, like President Ghazarian's department, or whether you're working to advance justice, the fact is that BU2 members, in conjunction with all of the other state unions and state members, state employees, have been working incredibly hard to advance the state's interests. And the result of that is that we're now the fourth largest economy in the world. And that's thanks to telework. As we have to go back into the office, I want us to consider, I want to encourage everybody to join their union, to access their resources that are available from their union, because even though I am an attorney and President Ghazarian is an attorney, we're not your attorneys, and we can't give you specific legal advice. So my first bit of advice is for you to join your union. Join your union and ask for the services that I think that you might need in order to navigate the reasonable accommodation process, and especially the state interactive process. There are specific things that you should bear in mind, and I'm appreciative of the previous speakers and their tips in navigating the state's interactive process too. Before I go to questions, I just want to say one more thing. There was a report that the state released, that the Department of General Services released, and I'm going to read a few quotes from that report. Telecommuters who had mobility disabilities and were involved in the project found that their work-related stress levels significantly decreased as a result of telecommuting. Their effectiveness changes were positive, like the rest of the telecommuters. We did not specifically explore new job opportunities for the disabled. However, telecommuting clearly appears to benefit the disabled. Few information jobs have inherent restrictions to entry if telecommuting is an option for the employee. The same report from the Department of General Services discusses anecdotal evidence. One such manager reported that during and subsequent to the telecommuter's pregnancy, she telecommuted, and thus we were not shorthanded, which prevents an additional workload on an already overburdened staff. Another quote is, because of telecommuting, the employee was able to accomplish much work at home, including periods during which he was suffering from his disability and would otherwise have been totally on sick leave. Now, as I read these things, I'm sure everybody here is agreeing to those things, right? It's like, well, of course, 1 + 1 = 2, Peter. But the reason why I'm slowing down and emphasizing these quotes is because this report was released by the Department of General Services in 1990, 36 years ago. Think about that. The state knew or should know that teleworking is a powerful tool to ensuring the rights of the disabled. 36 years. Now think about that. There are some listeners who might not even be born in 1990, okay? So let me paint a picture about that. In 1990, the phones were nailed to the wall. The phones were not something that you put in your pocket. And as a result, the technology, my point of that is that the technology is a little bit different in 1990, but the concept is exactly the same. The ability to work from your home was an astronomical and phenomenal tool. BU2 members have enjoyed that telework right and privilege since way before COVID, I think going back to the early 2000s even. And we knew that telework was going to be a powerful tool, and it was going to be a productive means of performing work. So when I say that the RTO mandate, the executive orders, the 4-day return to office is a setback, I want you to think about it in the context of a big picture and zoom out. I know that these are specific challenges, and I wish I had a magic wand to be able to solve it right now. But while we are trying to problem solve this particular barrier to state employment entry and employment, I want everybody who can hear my voice to be encouraged and to stay strong, because together I think that we can overcome these obstacles, and I hope that you'll keep sight of that prize. And with that said, I'll turn it back to President Ghazarian and any other questions you might have.
Thank you. You just kind of snuck that in, and I think that was really interesting. Great find. Peter and I haven't coordinated prior to this talk, so it was a surprise to me as well. I'm 87, so I kind of remember those days. But yeah, it's wild to think how much RTO is not about the employees' interests, disabled, not disabled, how that's no part of why this is happening. And it just makes you want to hit your head against the wall. But yeah, why don't we go into questions? I'm sure we'll have things to
Right. Thank you so much, Peter. When you mentioned 1990, that made sense. Back then, we had a different governor. We had different DGS leadership. Now, that all makes sense, but you're not going to get that report today. But anyway, there were a couple of questions came up. Obviously, cases been very active in pursuing various remedies and relief from numerous channels. One of the questions that talked about is that, this person writes, "Thank you, Case, for all your work, your current contract fight, pushing the AB 1729 and the CEQA challenge and the ULP charge with PERB. The unfair labor practice charge with PERB. How is that going, and what is the current status, or is there any other activities legally that case is pursuing? And this question is posed to both of you, President Ghazarian and Mr. Chau.
Peter, I'm not sure if you're better suited to talk about the ULP, um, but yes. So we have the CEQA suit, which is an environmental action, environmental act, and we need to kind of make determinations on whether or not we'll be continuing that line of action. It really comes down to whether they believe that the departments had any discretion in implementation of the mandate, and so far the judge isn't really buying that argument. We might try to prove that up a little bit further, but we need to make that decision. We have a board meeting on Friday, actually, but we are noticing that even just you know, everything is about building pressure. And that was one way we were adding pressure to the situation. And by filing that CEQA suit, it seemed like we started hearing different things when we were meeting and conferring with the departments about the mandate. And we started to hear that, they have no discretion, they have no discretion, they have no discretion. And actually, for our unfair labor practice charges, it's really helpful to hear that they have no discretion. So, though it was problematic for our CEQA suit that they're claiming no discretion, the fact that Cal HR is telling us we need to sit down and bargain with the departments, and the departments are saying they have no discretion, then what are we doing here, right? This is just surface level BS. Thank you. Unfair labor practice. So it's been interesting to see the kind of interplay of the tactics as well. We Peter and his team have been like working with a lot of members on grievances, and he can kind of speak to that as a form of pressure as well. I'll pass the mic.
When they say they have no discretion, there are exceptions made in the governor's executive order about reasonable accommodation, and some departments are following some directive from Cal HR. If you live over 50 miles away and you had telework agreement in place before this directive came to exist, then you could be grandfathered into that. All of those things are exceptions to the mandate. So I'm a little confused when the department's saying we have
I know
no.
you're preaching to the choir. I get that. So we have to kind of figure out whether we feel like we can better explain those exceptions. And we've also seen exceptions in terms of when departments are implementing based on various issues. Yeah, whether or not they're extending the 50-mile exception, whether or not they're immediately implementing. Um, we have seen departments that are not under the governor decide
Mhm,
whether or not
mhm.
they want to just opt
Right.
into it. Um, but we weren't heartened with the judge's kind of initial ruling. But we'll figure out whether we think we can kind of move the needle on that further.
Great. Thank you so much for responding to that question. Anyone else have any question? Alex?
Yeah, I was going to ask, as members of CASE, have you noticed an increase of employees with disabilities in the group you represent? And if so, have you noticed a decrease as a result of the incoming and now in effect RTO? And additionally, with regards to accommodations, do you see changes in accommodations being provided impacting people with disabilities, whether temporary disabilities or permanent?
Peter, you want to take that one?
Okay, so the first question was increase in employees with disabilities that we represent. I don't know. I don't know how to answer that because I was only just elected about 8 months ago. But I know that for me, I think that what I wanted to do, part of this new vision for CASE is to ensure to have a big tent, literally. What I like to describe to my members is that this is a infinite size big tent with unlimited seats. And hopefully as many people as possible can come into the big tent, so that way we can train them up as local reps, or whether they want to deploy as whether they want to focus on reasonable accommodations or representing their members during the state interactive process. Because our members have a right to union representation through local reps. So there has been more activity, I can say that. Quantitatively, I don't know how much is, I haven't quantified that. because I'm just trying to get out as many answers as possible to our own members. I'm sorry, can you repeat the second question? The second
Oh,
and the
that's fine. I just want to clarify. So you're saying you've seen an uptick in interest in disability related issues as a case member?
That's right, definitely an uptick. And then do I see a change in accommodations being provided impacting people with disabilities? Um, I would say that based on what I've been seeing about the state's interactive process, look, it seems to be very department specific. CalHR has released a model set of RA policies, but did not require state departments to adopt it. And unfortunately, that model policy has some issues with it, like for example, a lack of time frames or some type of lack of clocks about when a member must reply or when the State Department must apply. So as a result, the state departments have this ability to be able to individualize their own reasonable accommodation policy. So it seems to vary. What we're seeing is one end of the spectrum where there's some reasonable accommodation coordinators that are engaging in a good faith process with individual members. And then there's other state departments that seem to have blanket policies that apply prior to even the state interactive process even beginning. That's very interesting to me. So, you know, like one of the previous attorneys mentioned before, the state interactive process is supposed to be a very individualized process and it's supposed to be very fact specific. So these blanket policies, such as department will not consider X, I'm very interested to hear about that, and I hope that that's discussed in future meetings here. I would encourage any reasonable accommodation coordinator to continue brushing up on what the law says. There's a difference between uh, what what a decision maker's desire is versus what the law is, and I hope that we keep a distinction between those two, because the executive order that mandates the 4-day RTO specifically calls out exceptions on a case-by-case basis, including reasonable accommodations. So going into going in and into an interactive process with the idea that the person should come in for a minimum of 4 days a week, that's not part of that. That doesn't make sense to me. That doesn't add up. So with that said, none of that is legal advice. Those are just general musings to answer Alex's question, and
I
hopefully,
just wanted to ask, sorry to jump in, like the audience really is in terms of collecting information from our members about like disability status, if there's any kind of thoughts or best practices, because we in part couldn't answer that question because we don't collect that information. We're just starting to better kind of inform our CRM system so we have more information about members so we can organize our members better, including their actual participation in various events or not, so we know how to mobilize. And we can add a column for everything: t-shirt size, disability status, etc. And so if people have thoughts on that or have experience with other unions doing that or not doing that, please put that in the chat. We'd love to follow best practices or consider them.
Great. That's a good, fantastic ask, and the audience will respond, hopefully in the chat. We do have Sarita. Please unmute and ask your question.
Good morning. A lot of great information here today, and I thank you, presenters. My question is around, Peter, you said, look at the law. And the law talks a lot about the essential functions of the job. And so when we as accommodation coordinators are looking at duty statements, a lot of these jobs are computer based, and they have a disability or limitation that doesn't prevent them from doing any of the essential functions: reading reports, typing into a spreadsheet, data entry, things like that. But it could be something around focus, distraction, some other lighting issues. And the department is like, well, come in, we'll get you a footstool, we'll put some sunglasses on you, we'll give you a warming blanket, we'll do all these things, but you're going to come into the office. I'm struggling with ways to really advocate for the employee while also not putting myself in hot water with the director's office because I am viewed as a little too employee friendly, if that makes sense. I don't know how to focus on the law part when there are some technicalities in a duty statement that don't help me. Does that make sense?
Yeah, makes perfect sense. Or at least to me it does. So I want to thank you for your question. The first I gotta ask, and I don't mean to put you in a hot spot. I'll just ask it rhetorically. I'm assuming that you're represented, and I hope that you've joined your union so that way you can pose this question to your service member, or whoever is processing member requests. Because what you described is a very sticky situation because you want to protect your own job, but at the same time, you don't want to be written up for insubordination or not having obeyed direction from your decision makers or your chain of command. And I understand that. Uh, the fact is that um, after 6 years of telework, full-time telework, for many of the members that are within case, they like the situation that you just described, Ms. Lee, enjoy telework and were able to perform their job duties, the essential functions of their job duties remotely 100% of the time. So when we're going into when we're going into the interactive process, that is a fact that should be considered. The fact that this can be performed 100% from home, and especially for those with invisible disabilities, in which a footstool will not help with distraction or focus, or which dimmed lights or these other proposals, alternative proposals, they don't address the actual they don't actually address the impact to the life activity. That's the reason for the a reasonable accommodation request in the first place. So, I commend you for recognizing the importance of the RA process. I don't, in terms of framing, I don't think that's employee friendly. I think that's you doing your job. I think that you reading the rules and understanding that this is an important process, and that when an employee is coming in with the proper medical documentation and making this request, that it's reasonable. So I just want to thank you for that, and I hope that you'll continue persevering.
Thank you, Sarita, for the good work that you do. And, we oftentimes gets complaints like that. They're caught in a rock and a hard spot, trying to execute the mandate in one hand, try to balance the reasonable accommodation statutes that they're familiar with, and then the pressure from the leadership telling them to do one way or the other. And it's difficult for them to manage that and balance what you just mentioned. So that was a very good question. Any other question for the guest?
I don't have a question, just a comment. And this was about the data collection effort of case with regards to people with disabilities. I just from my personal experience in speaking with others on the state level of employees and seeing how difficult it is, for example, CalHR to obtain accurate information of people with disabilities, disclosing that they have disabilities, which goes into their statewide reports. I believe, at least personally, that a lot of it can be due to culture of agencies, because an agency that has a great and accepting disability culture may elicit more responses that are disclosing that their staff have people with disabilities versus an agency that does not have as good of a culture, and thus may end up incentivizing, in a way, employees to not disclose that they have disabilities because they're fearful of repercussions, even though the information that is submitted to CalHR is confidential and not specifically distributed to anywhere else. For example, if I say I have a disability to CalHR on that survey, CPUC isn't going to find out. But there's still that concern that the information is distributed outside of the source that's supposed to be confidential. And so I say that as context that perhaps CASE would want to ensure that its membership understands that the information submitted will not go outside the walls of case, and it's simply to get a census of sorts of what you're looking for.
Thank you. And I'm seeing a lot of comments coming in. Some of them unfortunately are not things we necessarily can kind of speak to because we're not experts in disability law. We're just happen to be lawyers who are part of a union who actually are kind of new to dabbling in this world because we weren't even really supporting members and reasonable accommodations, et cetera, prior to our term. So we're really learning alongside you. Also, sorry for not being able to answer some of those harder hitting questions. Hopefully, some of the other speakers might be able to.
Yes, our next speaker will actually address, she's an expert from,
Wonderful.
she's an attorney from Civil Rights Department. So we'll wait. And we also have someone posted a question about the survey and so forth. And there is a representative who's present, will be speaking from CalHR later on. And you can post that question at that point during his presentation and segment. Candace, you have your hand up, unmute, ask your question, please.
So much. I just wanted to point your attention to the chat where there seems to be another question from Sarah Granda, who's unable to raise her hand.
Oh, okay. Understood. Sarah, if you want to unmute, go ahead.
Hi, I guess I just wanted to ask, like, as attorneys, like, in case, right? What if case attorneys seeking disability accommodations, what if because of either, level of education meeting with level of disability, right? What if you don't have accommodations that fit that employee, and it doesn't to fit into like a box of an accommodation that exists, right? What's the process? That's my question.
I'm not sure how well I can speak to that, but from what I'm learning is that no one should be limiting themselves to a box. Nobody necessarily fits perfectly into in a box, and we hope that the interactive process allows for kind of a tailored solution that works for each member that hopefully the department won't push back against for kind of no good reason, as we heard from the previous kind of question asker. Unfortunately, sometimes happens when it's quite clear the easiest solution is sometimes working from home when where all the accommodations already exist for kind of daily life.
I wish as attorneys we would really challenge that, especially kind of to lead like by model or whatnot, right? So I don't know. I just think that it's hard when it doesn't fit X accommodation or X accommodation because you don't meet or look the part, right?
Yeah, I think we struggle with a few things as attorneys. I know, we're such beloved individuals, just kidding, by society. But no, obviously attorneys who work for the state do some really, really amazing work, but we also struggle to see ourselves as workers. And so we are in this union, but our membership many members don't think of themselves as a part of the labor movement or as workers. And so that's also just like a culture we're trying to change. So people understand, because as many have said before us and will say after us, like, we are stronger together. Like, the end, full stop, that's it. And so that's something we're slowly trying to change, and we have a lot of learning to do as attorneys on that subject.
Any other questions for President Ghazarian or Director Chau?
Just continue to encourage folks interacting with us in any and every way. Like you heard, we're still learning. We're trying to apply pressure in any and every way that kind of makes sense. We're not the experts. We're just kind of doing the best we know how to do as we can fit in between our job, our family responsibilities, and asleep. So again, thank you so much for having us here today.
Yes.
We've gone for a little bit longer, but might have to get back to the day job, unfortunately.
Right.
Thank you all.
Right. And as state workers, we all have day jobs, right? So thank you so much, President Ghazarian and Director Chau, for presenting and being here. Please come back and be with us. And if you wish to present any further information, you're always welcome back.